No problem. Let's do a rewind. Perfect. Good morning once again. I would like to call the February 16, 2023 APCD Hearing Board special meeting to order. Madam Clerk, can you please call the roll and swear in witnesses?
Good morning, Madam Chair. Thank you. Before I call the roll, I would like to note that all members are participating via teleconference. As such, all votes will be taken by roll call vote. Member Gonzalez?
Present.
Member Powers?
Present.
Member Spencer?
Present.
Vice Chair Schlick?
Present.
Chair Rodriguez?
Present.
Thank you. I would ask that the following individuals please identify themselves for the record. Hearing Board Counsel.
Emily Helm, Senior Deputy County Counsel, Counsel for the Hearing Board.
Air Pollution Control District staff.
Dan Plotner, Program Coordinator.
Mary Mahoney, Civil Actions Investigator.
Vera Tiagi, Counsel for the APCD.
Thank you. I will now swear in those that wish to provide testimony on any item on today's agenda. This includes petitioners, respondents, and APCD staff. Please turn your video on at this time and raise your right hand for the swearing in. Do you solemnly swear or affirm that the testimony you give in the matter before this hearing board is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Madam Chair.
Thank you, Madam Clerk. Before we proceed with our administrative items, have we received any requests from members of the public that wish to address the board today on non-agenda public communication, Madam Clerk?
Thank you, Chair Rodriguez. We have received no requests from members of the public to address the board under non-agenda public communication. However, if there are any members of the public on the teleconference line wishing to address the board under non-agenda public communication, please raise your hand now by pressing *9 or using the raise hand feature on Zoom. Madam Chair, seeing no hands raised, there are no members of the public wishing to provide non-agenda public comment at this time.
Thank you so very much, Madam Clerk. The next agenda of the item, which is the only one, it is the revised hearing board rules of procedure, which definitely have governed, the hearing board now for a long time, and they definitely need review and revision, particularly post AB 423. And certainly, it's good governance, for any board to review and revise accordingly, the rules of procedure. So we will now open the discussion. And then I would like, to have, that Ms. Helms, Emily, are you here? I know that I hear your beautiful voice.
Yes, I am.
Okay. As I've mentioned before, I'm a little bit sick here. Definitely, I'm going to lean on you heavily. Today, that to guide us, through this process. Is there any, guidance, or any information that you would like, to share with us before we actually get started?
Oh, at this point, we've just, we went through, we proposed some updates, mostly just to be, for consistency and keeping up with the times. So other than that, we have proposed our revisions for your review, and I'll be available to answer any questions.
Perfect. So thank you so very much. So does the hearing board council then have any suggestions for us to document, the changes, as we actually discuss those?
I have sent my copy of the proposed changes to Mia for her to share, because I am terrible at trying to share things and she's much better at it. So I believe, Mia, are you ready to show our proposed revisions?
I am.
Oh, great.
Perfect. And we actually, before we get started, definitely, this is an opportunity, that to certainly, work here, because the APCD also had an opportunity to provide, their comments, to the rules as they appear. So, and I wanted to ask, whether or not the district, if the district has prepared a presentation for the suggested revisions, and they would like, that to share those, with us, right now.
Thank you, Madam Chair. The APCD did submit a comment letter on or about February 16th, which I don't know why this says, but anyways, I did include our comments on the draft that Emily had prepared. So I think our position is that we're prepared to answer any questions that the board may have as they consider our comments.
Thank you so very much, Ms. Tiaki. Well, if that is the case, then the next questions are going to be, for the board, but let me actually just, indicate, some ways so that we could actually address this. In my experience, I find out that it's much better just to address, every single rule one by one as they appear. Certainly, this will not be the last instance in which we would actually see these, that rules as we actually see them. We don't need to vote on those today. We're just actually looking, for those revisions and the align. So, in addition to, the rules and the content of the rules as proposed and suggested revisions, personally, I would like to see, for us to also discuss how better to present this to the public, for example. I think, that a table of content to be added as well, in addition to separate this according to affinity, so these are the rules and this is the definitions. I think, a table of contents would definitely help anybody, that who's actually perusing through, these rules of proceeding, excuse me, of procedures. So are there any other suggestions? How would you like to discuss, and how would you like actually to address, this meeting today? That's my question for the members of the board.
I would agree that maybe going one by one and just kind of seeing, the consensus on commentary and or suggestions would be helpful, as long as we, just kind of move it along. I know the last couple times we didn't have things in the best format for discussion, but it looks like we're on the right track. So I'm really jazzed about the potential for today's discussion.
Yes.
So yeah, I would concur, Chair Rodriguez.
Yeah, I agree with you. It was I was able to understand them, so that was good. Any other comments?
Oh, I might just add that if a change seems mundane, or you don't really, if you've already reviewed and you don't have any concerns, we don't necessarily need to, go have a thorough discussion. The board is.
Yep.
It can
Yeah,
address
we
each
could
comment.
just say like rule 1 looks good, right? Stuff like that.
Move on and move on.
Precisely.
That is correct. So. Well, I guess now that with that, I think that we're ready. That's all.
So,
about
Chair Rodriguez, I have a question.
Hi. Yes.
More of a procedural question. Just because I'm an alternate member and member Powers is here, so I'm not a voting member today. I just wanted to clarify that I have I don't need to be sworn in, that I'm as a sort of an alt member of the board that I can comment on these things. Is that correct?
Definitely you may not vote, however.
Okay,
that's
right.
my understanding, but I'm going to defer that to Ms. Helms. Ms. Helms?
No, Mr. Engelman, we're very happy you're here, but we think as an alternate, your comments would be as a member of the public, which all members of the public are welcome to comment.
Okay.
But we're really happy to have you here and hear your commentary. So.
Okay, then if that's the case, I haven't been sworn in. I probably should be sworn in now.
So unless you're providing testimony,
Okay.
you wouldn't be sworn in. It would just
Just commentary is okay
don't
then.
have to be sworn in.
as any
Okay.
member of the public would.
Gotcha. Okay, thank you.
Thank you, Steve. So, well, let's actually get started then. The rule number 1, is general. The APCD submitted, their comments. They would like, to amend the subsection B to provide flexibility for the location of the meeting. And another element, was, no, that was the only one. They wanted to add the location of the meeting to be at the San Diego APCD headquarters, or that meetings may be held remotely. And that is for item B. Mia, can you show that? Definitely. Thank you so very much. And you cannot do split screen, can you, Mia, on Zoom? I haven't learned to do that yet. Okay, so.
I'm a little wary of trying anything right now with the luck that I had this morning, Madam Chair.
Okay, I am not very successful at doing split screen, and to be honest with you, once I show, I haven't mastered that one. I mean, but
I can
definitely,
try to pull it up. Do you want me to try to help?
no, I mean, I think it would be much better, I mean, that if me actually shows.
Okay.
So the rule number one suggestion, I mean, to be amended, I mean, is to provide flexibility for the location of the meeting. For instance, the location of meetings may be at the San Diego APCD headquarters, or meetings may be held remotely. So Mia, you're going to be toggling in this case. Could you go back, I mean, to the revised rule of procedures, from council, so that we can actually see how they actually stand today? And then, I mean, that if we can adopt, the suggestions from the APCD. Yeah, perfect. Thank you. There you go. You're going to be toggling back and forth. So, I mean, as you can actually see, I mean, that in B, the APCD is suggesting, that we add that in addition to the hearing room, I mean, that at the county building, that we actually do, incorporate, the APCDs, I mean, the headquarters offices, I mean, the in all groves.
Okay, and so what I see also is our previous rules just had an A and a B. The B had day or days definitions, but now we're suggesting having A, saying it's adopted pursuant to the health and safety code, and then change the former A to B with the addition of allowing for teleconferencing. It looks like anytime we have words in red, those are additions to the prior rules. So just, FYI, because I'm looking at also like the very, very old ones. And then the other thing I wanted to mention was just the prior page, Mia. It says Rules of Procedure 09.22.23 revision. I think you meant, or I think we mean, that we talked about this on September 22nd, 2022. So.
That is correct. That was the last time that these documents were presented, or the last time that there was any actual discussion.
Yes. So I just was confused a little bit, and I think I figured that out, that it's supposed to be 2022. So anyway, so then number one looks good to me. Does anyone else, as it states there with the red additions and the subtraction of the day or days, and putting that into the Rule 2 definitions? That looks good to me. Is anyone else?
And then, I mean, you are actually proposing, however, that we add, I mean, are we replacing, I mean, and I think Ms. Mahoney is here. We're not replacing the air pollution control, there's the site at the county offices, I mean, in downtown San Diego, but we're adding, the APCD headquarters, I mean, address. Is that correct? I mean, Ms. Mahoney.
Yes, that was what our recommendation was.
Okay.
So like, for example, after that first sentence, I think it's in B, you could add like, or the location as indicated on the publicly noticed meeting agenda. I think we had discussed that on September 22nd.
That is correct.
So I guess we need to add something to that then.
Yeah, so we're still in Rule 1.
Which shall
Rule
be
1B.
held in the designated hearing room. So maybe between the first sentence and the second sentence of Rule 1B, we need to add that suggested, or maybe add the San Diego APCD headquarters.
Or just as noticed.
Yeah, or as
eliminate, the location, and then just follow as noticed, I guess, in the public notice. Would that be acceptable? I mean, that makes sense.
Yes, I believe so. We would probably want to go ahead and specify our primary standard meeting location, which I believe is the CAC, or I'm sorry, the County Administrative Center. Is that correct? We could
Yeah.
say perhaps the county administrative center unless otherwise noticed on the agenda, or something to that effect, unless we intend to meet at the district.
The county administrative center is the one that's down at Pacific Highway, not the one that's in Kearney Mesa.
Yes, it was at 1600 Pacific Highway.
Okay, designated hearing room, okay.
Sorry, this is Vera Tiagi, counsel for APCD. Mia, I know there were conversations about looking for meeting rooms for the hearings. Do you agree that we have now identified the CAC will be the location, or is it still up in the air?
It will be meeting by meeting basis. We are attempting to have the meetings here within the headquarters off of Old Grove. However, due to the logistical needs and perhaps even renovations, we may need to meet at alternate sites on occasion.
So Mia, could you pull then the red back up, because maybe we, B on rule number 1 could just read, this rule shall apply to all hearings, before the hearing board, with a primary, and then just put the county administration, the building in, or, as per, the public notice. And we should cut it there and then allow the clerk of the board the flexibility, to hold the meetings, depending on the meeting room availability. So the rule shall apply to all hearings. We can leave that there, or as notice, in the, public meeting notice, and just cut it like that. And that would cover teleconferencing, different public, locations within government, where we would actually meet.
Well, we do need to have the teleconferencing option in there, I think. So I think, or at another location as noticed. And then I would keep that last sentence, the meetings may be held by teleconference from time to time. I think we definitely need to keep that, but I think keeping the flexibility of just, or at another location as noticed, I think that's great, Chair Rodriguez.
Okay, perfect.
So for subsection B, what I have in my notes is these rules shall apply to all hearings before the hearing board of the APCD, which shall be designated in the hearing room at 1600 Pacific Highway, unless otherwise specified in the publicly noticed agenda. The meetings may also be held via teleconference from time to time in accordance with applicable law.
Oh, I really like that.
I like that.
That's really perfect.
Okay. Good. Any comments from the members of the board, APCD, anybody else? No?
I have a quick comment, and I might have missed my opportunity earlier, Chair.
Good. Yeah, no, please go ahead.
And that is that I did look at all of the track changes, and they are voluminous, and this is pretty dry stuff. Could we get a held by the hand here by whoever at the district did those track changes, who can tell us, hey, this is just moving the deck chairs here, and this is where we added new language, so we don't go line by line?
Perfect. So I'm going to be, then I was a little bit closer to this process than you, Bill, and you actually bring a very good point. So for me, definitely the familiarity is there, because I've been working behind the scenes. So I'm going to actually ask Emily maybe to introduce every single rule. And just as you indicated, indicate why the changes are here, in that specific rule, and what was made or not. Thank you. Thank you. Definitely, that is definitely very, very considerate of you on that one. So, Ms. Helms, would you be willing to do that?
Oh, I'm happy to. So, starting with rule 1.
Yes, please.
Okay, so these changes were proposed to rule 1, basically to clarify our authority to adopt the rules, and then also to, as the district noted, give us some flexibility as to how we perform our meetings.
Yeah, and when we go through, if someone could just point out what is new, what wasn't in here before, and not just a moved piece of text, that would be great.
Yeah, And then, if we move to number 2, then Emily, you may want to explain, what appears in red, the redlined, that document, as it compares not to the original, the one that is actually effective currently.
Oh, sure. So let's see. Rule 2, we just added some definitions. I think our intent was mostly to just put all the definitions in the same location.
Correct.
Good.
So
There may be a few additions.
Yeah. So that is correct. And that was something that I think that is needed. The member powers, because we did not have one last time.
And just to be clear on my end, I don't need an explanation. You can just tell it. If I have any questions, I'll ask them. But
okay,
you don't need my approbation to keep moving.
No, thank you so very much. The district, however, in their paper, presented by Ms. Tiagi, that's not true. I think it's Ms. Mahoney in this case. Also suggested additional definitions. For the list. And they are suggesting, the addition of the Air Pollution Control Officer, APCD rule, continuance, hearing board. And then they are proposing, as they indicate in their position paper, which is now shown, to eliminate, breakdown condition, emergency variance, interim variance, and regular variance from the list.
Okay, so adding more definitions seems fine. I'm not sure I like the idea of taking away definitions of things that they may be defined by statute, but what we're trying to provide is guidance for those who are interested in how we work, and having these definitions that are defined by statute in our hearing rules, I think, are helpful for maybe lay people or just us as hearing board members, because not everyone serving on the hearing board knows where to go and look at the statutes at how these are defined. So to me, I would like to accept the additions, but not accept the suggestion to take away the definitions. And then just on a formatting note, I was just thinking we could put in quotes every word that is defined. So that's all. So those are all my comments on this one.
No, thank you, Vice Chair Schlick. Any other comments from the members of the board?
Yeah, I agree. It's helpful to have those definitions in there, but I don't know if any language needs to be put in there that says or as otherwise defined by statute, just so that we don't run into any legal conflicts in terms of what constitutes each of those things versus not.
No, that's very good. Thank you, Dr. Spencer. Any other comments? Good.
Actually, I've got one comment or question, perhaps. When I was reading through this, I was reading rule, and I'm kind of accustomed to APCD rules sort of being the default for rule. In the case of the hearing board rules, when the hearing board rules specify rule, they're referring to the hearing board rule, and we're adding a definition of APCD rule to clarify that. I guess I'm wondering if we need to be more clear, like instead of saying rule when we're talking about hearing board rule, adds a lot of words to this, but if we need to be defining what a hearing board rule is and then calling each one a hearing board rule when we're referring to that versus an APCD rule.
You mean, like, for instance, in this Rule 2 definitions we've got for purposes of Rule 17 mentioned quite a bit?
Yes.
Yeah, I think that's definitely an ambiguity that we should clear up.
Mm-hmm.
That's a lot of changes.
I believe the suggestion is that we should be referring to hearing board rules each time we we want to refer to either a hearing board rule or a district rule in each reference?
Yeah, each time it should be specified what rule what type of rule we're referring to, whether it be a hearing board rule or an APCD rule. I think those are the only two that are referred to in here. But when I was reading through it, you know, with my previous history, when I think of rule and we're talking about APCD, I always thought of APCD rule. And I finally figured out when I kept trying to reference the rule from the APCD book that it wasn't the same thing. I finally figured out that it was the hearing board rules we were talking about.
I'm sorry, I didn't mean to cut you off.
That's okay. I made my point.
Oh, I think so. We might be able to address this by stating that all rule references for purposes of this document shall be hearing board rules unless otherwise specified as a district rule.
That would be fine with me.
That's very good.
Yes.
I give you another one. I think, you know, that I'm reading also in some instances, and that's something for us to pick up. Maybe the use of regulation and as part of APCD rule, regulation or rule. So I know that I saw it. I'll find it soon. But regulation, we may actually have to, you know, I mean, take a look at the regulation as well. But I definitely agree with you. I mean, I do not agree, you know, I mean, eliminating this definition, because this is a quick guidance, I mean, for anybody who actually can read this, and or to look, you know, for more information. Yeah. But definitely, I mean, I agree with the district on adopting the additional definitions that they propose.
Ms. Helms, do you think that that language that you just shared about the unless otherwise specified all rules, should that be like a footnote, or just should it be under like Rule 1 general, or
you know, that's interesting. We could put it in the definitions, or we could put it in general. Yeah, I think it might fit well in definitions, because we could say rule means this unless we specify otherwise. If that works for the hearing board.
Yeah, I'd rather take it there. I mean, so it goes really very well for the general or whatever scope we actually have. Yeah. Okay, this list is getting longer. Any other comments from the members of the board? Good. Moving right along, let's actually move you know, to rule number 3. So just stay here. I mean, Mia, the district actually is proposing at the following. It says at hearing within quotation marks before board, for consistent with Rule 2 definitions and with term as used in the Health and Safety Code, which is used to distinguish the hearing board from the APCD governing board. That's true. Okay. You know, so can you toggle back, I mean, to the red lined? I'm sorry, I forgot. So Mia, could you please go back, you know, to the red line one? Yeah. Mary, I see your hand, you know, so thank you. Pretty soon, let's please go ahead. I mean, address your question now while Mia can toggle back and forth between the documents. Thank you.
Okay, thank you, Chair. Briefly, I found a typo just now on Rule 2 definitions for APCD. So the typo is that we need to change the title. It says right now currently County of San Diego Air Pollution Control District. The county of should be deleted before the word San Diego, and then it should say San Diego with the insertion of the word county air pollution control district.
So it would be San Diego County Air Pollution Control District. That's how it would read.
Yes, for the definition of APCD.
Okay. So we'll get back, you know, to your letter. We'll address that. I'll make a point, I mean, so that we can show it. Okay. I mean that, but me, I just found out, you know, the red line. Just with a technical issue. You know, I mean that's so Mia, if you can go, you know, to rule number 3, please. Next page. Perfect. I mean that's so Emily, could you please present, you know, I mean the changes that we have made here?
Oh, yes. So here we just proposed some changes to add some flexibility for if neither the chair nor the vice chair were present. It's basically codifying, not codifying, enumerating in our rules our existing practice of having another member serve as chair, and allowing those duties to be delegated in the absence of the chair or the vice chair.
Good. Comments on that one, again, with the exception that, you know, the APCD is requesting, oh, I didn't actually.
This one looks good to me, and
It's
I
my
like
page.
the,
Go ahead.
this
Sorry.
one looks good to me, this rule 3, as changed, and then with the suggestion of changing, adding hearing before board, wherever
Yeah.
it says members of the board instead of members of the hearing board,
Yep.
chair of the hearing board, members of the hearing board, that seems fine, seems helpful.
Any other comments from the members of the board?
No comment.
Okay, thank you. So if that's the case, no, let's yeah, let's move then, you know, I mean, stay here. We're gonna do a little bit of, you know, I mean, the parting on this one. If you can go, you know, I mean, the rule number 4, which has to do with minutes, preparation of record. So Emily, if you could present, you know, I mean, the suggested revision.
Yes, we suggested some revisions to this rule just to clarify the procedures for requesting transcripts. We've had some transcript requests and we wanted to bring that in line with the health and safety code requirements.
Perfect. The APCD, however, is also suggesting, you know, some revisions, you know, to the wording as it appears here. And they have presented this in a strikeout underline fashion. And I think that's where we actually got very, very lost last time. At least I did. So, Mia, could you please present on your APCD some suggestion on that one? Knowing that this is a challenge right now for you, I'm sorry. So Ms. Mahoney, I mean, for this rule number 4, I would like, you know, for you then to explain, I mean, the changes, you know, that the APCD is proposing, please.
Yeah, so in this case, we made a specific edit. And I think it was just to clarify the records retention and a little bit more detail about how the minutes are prepared. So let's see, I think you'll need to advance to the next page to see the remainder of our suggested edit at the top there. So just some clarifying phrases added. So we're including that another party might request, you know, might be a requester. And so that's the underlined portion on that second sentence. And then we just added detail about, you know, like I said, records retention. And so those are specific edits that the board can consider, you know, directly adding if they so choose. And then in the second paragraph, we're also suggesting to include how the recording is going to be done. So electronic recording, I believe, is probably how it will be done, but that could be clarified. And then either the fee for the records or where the fee amount could be found as a reference.
I have a question for you because I just want to see, you know, I mean, not kind of the how. If you actually go into the second line, you know, I mean, of your suggested edits here, it says, I mean, that I guess the votes of the members and when requested by second page, yeah. Next page, yeah. By member or any other party to the hearing. So, I mean, that implies, you know, that the person or persons actually have to be present at the hearing.
Yes, I think that was our interpretation and our thought on that.
Maybe let me this is Vera Tyagi. Any other party to the hearing would mean the petitioner or the respondent. So someone involved in the actual hearing. If they were under the health and safety code, any of them may request that the transcript be prepared. So we just wanted the rule to reflect that.
So, thank you, Ms. Tiagi. So can we actually put that, in there, so that is not either, the petitioner or respondent instead of any other party? Would that be okay? I think
that would be
that it would provide clarity to the statements here.
That would be fine with the APCD. I think party is commonly used by attorneys, but maybe that's not clear for everyone. So that's
no,
totally
it is very clear. I just want to make sure that it's unequivocal. Yeah. Go ahead. Vice Chair Slick.
So I do remember discussing this in September, that we were adding in because the former rules, as stated, just seemed to be like you had to be a member of the hearing board to request this sort of thing. And so we were kind of adding that any other party to the hearing. I think I'd prefer to keep it any other party to the hearing as opposed to just or any party, just because it's just a little more specific. So, but I still think it's good that we're widening it from just the hearing board members being able to request to any other party to the hearing being able to request. Anyway.
Yeah, I think it's a little bit wide. What was your suggested phraseology? The Vice Chair Slick, any other party or?
Yeah, so any other party to the hearing, I think, is wide enough, but also specific enough to, to limit it to those parties that, should be relevant, as opposed to, maybe just, I don't know, I guess I just, if it just says any other party, I don't know, it just could open the floodgates maybe. But I think any other party to the hearing keeps it relevant to those, to those who are present. Or have a relevant connection to the hearing to request the minutes. Does that make any sense, Ms. Helms?
I would definitely recommend limiting it to parties to the hearing, because you don't want to open the idea that just anyone can request this, because that would be it's more than is required by the health and safety code. As to whether we say party to the hearing or petitioner and respondent, I think it's pretty much one and the same. So I defer to the board members on that.
Parties to the hearing would be okay. The phrase "no" that is bothering me, to be specific, is the any other. So.
Oh, yeah. I see. The any other. Okay, so that's the part that's bothering you. Okay, so
yeah.
Well, maybe we could by a member, or the petitioner or respondent. Then that's another option that's specific, yet it widens it to those relevant parties that would have a need for it.
Yep. And then I would agree. We can definitely define that parties not to the hearing. That will be just fine. I think it will be clear. At least in my mind, it would be. Don't get me wrong, my dad and I had very good conversations about this. Any other comments? On this one? I also have another question. What is the applicable records retention schedule for the hearing board? Wouldn't that be defined by the clerk? Because I do not know what is the record retention that is used, by the hearing board, to be honest with you.
Do you mind if I answer that?
Yes,
this
please,
is counsel for the APCD. So part of the reason why we needed to make that or we're asking to make that change is the APCD is currently in the process of drafting a records retention schedule that is independent from the county schedule. So technically we're still following the county schedule, but at this point, I'm not really sure what the APCD record retention schedule will be for the hearing board. That will go through a public process, and we'll get input from, staff and the governing board and everyone else who needs to weigh in. So because we do not currently have one, I thought it would be better just to refer to the schedule, because I'm not certain what decision will be made regarding how long the minutes or transcripts will be retained.
Yeah. Okay. We're still working on that. Takes time.
Right.
Thank you, Ms. Tiagi. Any other comments from the members of the board? No. Well, that with the change, to, parties to the hearing, other than that, I am, okay with it. So, and then also, that we should identify, what the fee for the record could be found, because I know that those fees change. So at least know that I would hate, to actually see, a fee schedule, that, would sunset, rather rapidly. It should actually be dynamic.
If I can weigh in on that one, Chair. That is actually set by the relevant health and safety code provision addressed above. The fees are set there.
Well, if that's the case, I guess not that very good.
Yes, I do see this. So in the redlined version, it says the hearing board shall prepare the record. The payment is the fee specified in the government code, the 69950 of the government code. So yeah, that looks good. So
Yes, it looks good.
we'll keep it as that.
Mm-hmm. Yes, ma'am. Any other comments? Excellent. Now, rule number 4, on the red one. Thank you so very much, Mia, once again. Emily, if you could please, provide us the intro.
Oh, we're just changing the reference from chairperson to chair.
Okay.
Yeah, that looks fine. Shall we move on to 5?
Yes, absolutely. Rule 5.
Oh, actually, well, it was rule 5. It's going to be rule 6. So, right? Am I reading that right?
So rule 5 was the hearing board hours. As far as I actually get it here. So, and rule 4 were the minutes preparation. So rule 5 are the hours, isn't it? Yeah. I think that's good. Any comments on rule 5 as it appears in front of us? Good. Rule 6, disqualification of hearing board members. Mia? Excuse me, Emily?
Yes, I believe we were just trying to clean up the language here. It was a bit awkwardly worded. So,
that is so true. Okay.
This addresses conflicts of interest when a hearing board or a party may feel that they a hearing board member should be disqualified for an interest.
So I was reading through the red rewritten part here, and it's a little bit unclear to me in part. So we just might want to tighten it up. We don't have to do it right here right now, but like it says on the 3rd line, disqualification of any member by filing an affidavit prior to the taking of evidence in the cannots. So maybe in the, I don't know, we just need to kind of like review that again because it doesn't quite line up.
Oh, I apologize. That should be in the event. A fair hearing cannot be provided.
Yeah. Well, definitely, take a look at that, certainly.
The event, a fair hearing. Okay, great. Thank you.
APCD, however, submitted also, a request note for revisions as well. In their letter. They're requesting a couple of things. It says suggest to provide clarification if a party may request disqualification of a hearing board member by filing an affidavit or person testimony or either one. And the next, suggestion, it is, the taking of evidence. They're suggesting, to replace taking of evidence, that phrase, I mean, and I think, replace it with, within quotation mark, commencement of the first hearing. And that would certainly align, with, the other rules that we actually have. Member powers.
Yeah, I just had a quick question on the disqualification issue. I remember a couple of years ago, substantive issue is this. We had a pretty prominent hearing with the Navy a couple of times, and several of us on the board at the time had either worked for the Navy or we had contracts with the Navy. And we all, not all of us, but we basically explained to the board why we felt we should not need to disqualify ourselves from this hearing. And so my question for the council here is, has anyone defined, kind of good rules of the road for disqualification? Because it was basically left to us to, basically slap our hand on a virtual Bible and say, we don't feel that we should be disqualified. Like, that's a pretty loose standard.
Yeah, so conflicts of interest are defined by statute and at common law. So typically under the Political Reform Act and Government Code 1090, this would address the additional instance when perhaps a member of the public wants to bring to light a board member's potential disqualification, or maybe even if a board member isn't disqualified by law, if they genuinely feel like they can't give a fair hearing, that they should be recusing themselves. So this would be thought of as in addition to the already existing laws regarding conflicts of interest.
Well, I guess that's my question. What are the existing laws regarding conflict of interest? I don't recall us ever, being briefed, or
It's
maybe we were.
voluminous, that's why.
What's that?
It's voluminous, that's why.
But we can, of course, I believe, I would hope that we had addressed that in a training, but we can go ahead and set one up at any time.
Oh, no, we don't. I don't need to make this more complicated than it is. It's just that we've actually encountered a situation where we're on our honor to assert whether we should be disqualified or not. And it struck me at the time that I'm wondering if there is some, I'm a professional engineer. I have a 10-point ethical obligation I have to meet. Where somebody just writes it down, I might feel that I worked for the Navy for 5 years. I did good work for them. I have no obligation to them. There's no reason I see I should be disqualified. Then again, there might be a code somewhere that says, hey, if you worked for an entity for a few years, you just, to avoid any hint of conflict of interest, you shouldn't be hearing this case. That's really my question is it, and I know that professional engineer standard, I can read it in less than a minute. I'm just curious whether there's some general standard like that.
There are, but it's very fact specific. So if any of the board members has any questions, we would ask you to reach out to us and we can take a look at the particular instance.
Okay, thank you.
Thank you.
Thank you so very much. Always good conversation. Dr. Spencer.
Yeah, I was just going to add in those situations, because the rules are so voluminous, I think that the other members of the board should rely on counsel in terms of making the decision. And I'm not sure that necessarily needs to be specified in a rule, but should be something that we would all be expected to do in making the decision as to whether or not we should vote for somebody to be recused or not, should that situation come up again.
Good.
Okay. So, again, per the suggested, the edits, from the APCD, the APCD is suggesting, whether or not we need to request disqualification, very important, by filing an affidavit, open sworn testimony, or either one. Is that necessary? Ms. Helms, can you actually weigh
so
on that?
my reading of this as in the section as rewritten, the red text, red underlying text, seems to allow for either. That just the way it's written, because it says may request disqualification by filing an affidavit prior to the taking of evidence. Keep in mind that the prior version was may request the disqualification by filing an affidavit before the submission of the case. So what we've done is with the suggested edit, the rewrite allows someone to either submit an affidavit prior to taking of evidence. In other words, sometime after, when we start the hearing and when we start opening, start taking, when we either hear from petitioner or from respondent. So they could do that. Or it says in the next sentence, a disqualification request may be made prior to the taking of evidence upon the sworn testimony. So it seems like that's definitely providing two options. Because someone might, know ahead of time they want to write a an affidavit is basically, it's sworn, but it's in writing, and maybe they can't be there in person, but they still want to provide that to us as the hearing board. Or maybe they're there at the hearing board meeting and they realize right then and there that they've recognized a problem, a conflict of interest problem that they'd like to bring to our attention. So they say, okay, please swear me in as a witness, and I'd like to, request disqualification. So the way I read it, we're already providing the option of either or.
Yeah, agree. Any other comments on that one? And then, that they're also suggesting not to replace taking of evidence with commencement of the first hearing.
To me, I think that taking of evidence is clear, and why we're using that term instead of commencement of the first hearing is to allow someone to have the chance to request disqualification between the time when we open the hearing and when we start to take the evidence, right? Like there's time in between there where we, review the record, we have public comment, sometimes, we do the prior minutes, things like that. So I think if it was commencement of the first hearing, it would cut off a lot of possibility of someone being able to request disqualification. So I would suggest that we keep it at taking of evidence, only because it gives people a little more time. They wouldn't be cut off by the fact that they didn't submit it prior to us, gaveling in the beginning of the hearing.
Ms. Tiagi?
Oh, thank you, Madam Chair. I think I thought that this section was supposed to be like the Code of Civil Procedure 170.6, which is basically like a peremptory challenge. And what that means is that a party, if they thought that they couldn't get a fair hearing, they can request to get a new judge without having to explain why. Like within usually like 10 days of making their first appearance. It's a very small window of time. So this seemed like a hearing board version of that. It's not like they have to identify that there's an actual conflict of interest under the conflicts codes. It's just more like the presumption of, do they feel like they can get a fair hearing or not? And so, there's usually a short timeline for that, just so parties aren't, judge shopping, basically, which is, I think, why we thought maybe the commencement of the first hearing would be appropriate, although we're fine with a different definition. But on our end, we were not sure when exactly during the hearing is taking of evidence. So I guess because we thought we weren't really sure exactly when that occurs or exactly when that is. Like, is it when the clerk accepts things as an exhibit? Is it when, we start actually taking testimony? We weren't really sure what that meant. So I think we thought maybe something else was appropriate. Although, like I said, if commencement of the first hearing is too soon or anything like that, I think we're hoping that maybe we just would choose better, like a more clear time as opposed to just sticking with the taking of evidence. But so those are our thoughts on this. And also we weren't really sure on our end whether you had to file an affidavit or upon sworn testimony. So I think that because the current version has both of those terms in different parts of the rule, it's easier for someone to follow if at least those two terms are put together to say, filing an affidavit or upon sworn testimony. So that it's not like you read one and then later on in the rule you read the other term, because that's, I think, why it was unclear to us.
Thank you, Ms. Tiagi. But the the wording as it says right now, I get your point definitely, and I like to simplify as much as possible. It just says that such a request may also be made prior to submission. So I mean, just very clearly, Ms. Vice Chair Schlick indicated it provides those options. It becomes now like a matter of style. So. Any other comments? Or suggestions? The agreements or not? On the replacement of taking of evidence with commencement of first hearing. Anyone disagrees? That does everybody agree? That as it states, this rule shall stay as it appears. With the edit, and then we can move on. I think so.
Looks good to me.
Me too.
Same.
Excellent. Then, well, thank you so very much. Any other comments? No. Let's actually then move to quorum. Rule 7. So quorum, the APCD also has another, suggestion is just to modify second sentence to read concurrence of at least 3 members. Is required to grant a request in any matter except for emergency variance. I think that's it's clear. In the edits. If you can go back, Mia, to the redlined version. Good. Any comments on Rule 7? So this is again one of the rules I know that is kind of interesting here, because one of the comments now that the district actually indicated, and Mr. Agamel also indicated, is the utilization of the rules. This one says Rule 17, comma, emergency variance, which applies definitely to the hearing board rules 17 as they appear right now. Okay. The district also offered, that wording that should say APCD Rule 97, emergency variance. Ms. Helms, any comments, on the proposed edits from the district?
No, I believe the district just would like a reference to the district emergency variance rule as well.
Okay, that is the correct. Yep.
Oh, I don't see any problems with it. No.
Looks fine to me too.
Okay. So the change, it seems as though that it is APCD Rule 97, emergency variance. And with that, any other comments? So 97, oops. So stay. Thank you. Rule number 8, hearing by fewer members, hearing by fewer than 5 members.
Yes, these changes were proposed because the hearing board has an existing practice of allowing, when we have fewer than 5 members, allowing petitioners to request a reschedule date so they can have a 4 or 5 member board. This is because if you have fewer than 4 or fewer than 5 members, you have to get more members agreeing with you. So this is just something explaining our existing practice.
Any comments?
Seems fair.
Any other comments? Good. Well, thank you. Then let's move to rule number 9. Emily, that is for you as well. Rule number 9.
So we're looking at 9. I apologize. I'm taking a look.
Is effectiveness of action.
Oh, yes.
So the
Yes,
very
I believe
bottom-
that was proposed just to clarify when a decision would become when a decision would become effective upon the concurring vote of 3 or more.
Perfect. The APCD actually, submitted a suggestion for edit. And it has to do, with addition to item A at the very bottom, I believe. Let's see, yes. That indicates not to add the following, except a decision by the hearing board to initiate every hearing, which shall have no fewer than 4 members present as required by Health and Safety Code Section 40821. That would be 9. I think that is good. That suggested edit, I believe, that is relevant, as long as it actually calls for Health and Safety Code. Any comments?
Okay, so for so let's see, so for the effectiveness of action, the district the same. Concurring vote of 3 or more, absence or resignation shall not affect. Quorum is present, at least 3 members concur, and then adding a caveat to section A, accepted decision. Okay, so adding to A, which is on the previous board. Okay, yeah, I see that. Yeah, I think we should add that. That clarifies things.
Yep, I think so too.
So I would adopt the district suggestion for Rule 9 to add that to subsection A.
Yep, agree. Any comments? Okay, any objection? I think perfect. Okay, let's actually then move, to rule number 10, and that would be, the redlined version. Yeah.
Oh, yes. So this was added because we've had a few board members who have missed previous meetings, but they have reviewed the record and they want to go ahead and vote on the minutes. So this is intended to address that, to allow them, if they have reviewed the record, to go ahead and weigh in.
Yes, thank you. Thank you so very much. Any comments, on the proposed Rule 10? No?
That looks fine to me.
Good. But with no comments, no, then continue with Rule 11. Emily, Rule 11, that's just.
No substantive edits.
That is correct. Any comments on Rule 11? Perfect. Okay, so it stays as it. Thank you. Rule 12, which has to do with public comment.
Rule 12, there was a suggested to reduce the public testimony time to 2 minutes per speaker unless otherwise allowed by the chair. This is in alignment with the current County Board of Supervisors practice. And we had also referenced how the public can proceed, how the public can participate should the hearing be held via teleconference.
Any comments on Rule 12? Go ahead, Member Powers.
Yeah, I think 2 minutes is too short. It's fine for professionals who are used to making comments before the board, but I think we've seen time and time again when we get lay people, the first minute of their opportunity is spent fumbling around just trying to figure out how to communicate with us. So I would say 3 minutes at a minimum.
Thanks, Bill. Any comments from the members of the board?
Yeah, unless I'm mistaken, it sounds like it gives the chair discretion to allow a speaker to go longer. Is that a case by case basis, or is that something that has to be decided up front? I guess I would ask for clarification on that part of it before rendering an opinion there.
It's on a case by case basis, so the chair is allowed to give additional time. However, there's no legal requirement for 5 minutes or 2 minutes. So we would defer to the board.
I think I like the idea of kind of a default of 3 minutes. I agree with Member Powers. I think reducing it from 5 to a default of something less, though, is important. So I would concur with the 3 minute instead of 2 minutes.
Bill, do you have another question, comment? Go ahead.
No, Chair, I just failed to lower my hand.
That's okay. Yellow looks good on you, by the way, on Zoom.
Now, do I
Definitely.
have
Go ahead.
consensus of 3 minutes? Is that the board's preference?
I'm okay with 3.
Yeah, so then if that's the case, and also, I mean, the other comments? So let's actually make the change to 3 minutes.
Thank you.
You're heard too, so I mean, these meetings, so you listen to Bill. By the way, Bill and I know each other for a long time. Rule number 13, request for hearings.
Request for hearing, no substantive edits.
That is correct. The APCD, however, I mean, is suggesting the following, some edits, and it has to do incorporating APCD headquarters as the filing location for petition instead of, I guess, no downtown. And then, the provision of the 15 copies, because, I mean, definitely we submit everything electronically or is distributed electronically. And lastly, I mean, that they are also making references, to the additional subsection, the subsection D to reference IPCD Rule 42 for the fee requirements for emergency variances. So that is their, I mean, the suggestion for edits, which I think is fairly relevant. Any comments, I mean, on their suggested edits by the APCD? I just need to find myself on these rules. Okay, Rule 42. Yeah. The 15 hard copies is Rule 13, line, I mean, section A, 1, 2, 3, 4, 5, 6, 7, the 8th line. Yeah, I think, that those comments are definitely relevant in today's day and age. Any comments from the members of the board? I mean, on adopting, the suggested edits by the district? No?
So the suggested edit is instead of filing the petition downtown at the county administration center, instead make it the APCD headquarters. That seems fine to me. I remember discussing this previously in September about the documents could be electronic instead of copies of multiple pages.
Yep.
I don't remember what I think about that, but anyway, I would be fine with these edits. What do the others think?
No comment. That looks fine to me.
Yeah, I don't know if my only comment would be, I don't know if we want to give people a choice of filing petitions either downtown or at the APCD office. I'm just posing it as a question as to what people think of that, as giving folks an option as opposed to mandating one versus the other.
Ms. Mahoney, do you want to weigh on that one? How how are the petitioners now filing? Do they actually go the county administration building, or do they all go to APCD headquarters?
Well, I think our thought was in the future, as Mia had stated at the beginning of our meeting, the in-person meetings are going to be sort of on a case-by-case basis.
Mhm.
And so our thought was to incorporate or to add the Old Grove APCD headquarters location as another option for a filing location.
So let me interject that technically our clerks both sit at the Old Grove location. So if someone were to try to file downtown, we do not actually have someone on staff to accept the petition. And the county, we're separated from the county, so it's not the county clerk's responsibility to do that. So practically speaking, there's no way to have it filed downtown at this point.
So it's electronic, on the APCD headquarters in Oak Grove.
Correct.
Yeah, that was my understanding too. Actually, I challenged that one because I went there the other day. So thank you, for definitely for the clarification on that one. Ms. Yagi. Okay. So I think that then with the suggested revisions, that would be good. So there's no need definitely to have the 15 hard copies to that. So that would be good. Comments?
So it
Questions?
sounds like it needs to change to be, can't maybe filed in person at the APCD headquarters.
Yes.
Or maybe filed electronically on the APCD website, right? Something like that.
Yep, that's the only one. Yep.
Yeah,
That's it.
that's an important update.
Any other comments? Good. Are we ready to move to rule number 14, cuttings of petitions?
So on this item, we basically just wanted to update this to include all the different types of issues that come before the hearing board and the information we're looking for when those petitions are filed.
So we definitely have, the red line version, that Mia, and certainly, the suggestions from the APCD. So on this one, we actually have the contents of petitions. We have the type of petitions in definitions, but we don't have a rule that says types of petitions and the corresponding forms. Just to provide a guidance, to the petitioner. So I found, that, again, as you know, if everything is on a graph or a table, it speaks to me. It just goes definitely to really very deep into the contents of the petition. It says the request of emergency variance. I would love, to see either more of a, table format. This is the type of petitions and maybe the forms that you need to file or something along those lines. It would, I know that would be maybe something that the district, could actually provide as a form as well. We can actually say, contact the district, for the type of petitions, and this is what they're for. Yeah.
Madam Chair, if I may,
Yes, ma'am.
the current process for this office is that if a petitioner is unsure of what type of petition to file, however, they are seeking to file a petition, they are referred to the compliance division, who has their civil actions investigators that can assist with that, with determining the type of petition that they should file.
Okay. So, I mean, again, I'm just, you know, I mean, from the procedural standpoint, as I actually follow, you know, I mean, the process, if I was a petitioner, I would like to say, okay, these are my type of petitions, you know, that I have, and these are the forms, you know, because I think it would be really very sad not to complete, you know, the correct form. So I'm just, you know, again, maybe a rule that says, no, I mean, that these are the type of petitions, I mean, and maybe, you know, and these are the forms, and this is where you find them, that could precede contents of petition. So that my suggestion is not to add an additional rule that says, no, the type of petitions and where to get, you know, I mean, the assistance that is needed.
Madam Chair, I have a few concerns in that might not lend itself to a rule of procedure, in more that the forms are likely to change, if I understand correctly. That might be a better process for like the website. That would be my only concern there, but we could certainly add that if the board wants us to.
No, I mean, I definitely found that. I mean, and that's why I hadn't suggested it before. I mean, when we were working on behind the scenes, you know, but it just kind of jumps, you know, right directly into, you know, the deep end of that pool. Okay, you know, so get your little toes wet first. It may not be definitely a rule, you know, but we could definitely, I mean, say, you know, I mean, just, you know, add maybe a section A or something like that, saying, you know, this is how you actually go and get, you know, I mean, to the website, and then, you know, this is the content, I mean, for the types. I mean, I'm just trying to guide the person. Maybe this may not be the forum, you know, but just guide the person, I mean, who would actually take a look at this and want to get oriented, because it's complicated. And we've seen many people who have come to the board, you know, I mean, the first time, and they go, I just printed all these rules, and which form do I need to complete today? Bless their heart. We've seen those. Yeah, I think, you know, that I would actually suggest, you know, that we actually just take, even if it's just a subsection A, I mean, Emily, on at least know the types of, before we actually jump into everything else.
Okay, absolutely.
Thank you. Any other comments, I mean, on Rule 14? It's a long one, though. So,
I think Member Spencer has his hand raised.
oh, thank you.
Yeah, Chair Rodriguez, to your point about making sure that people are finding the correct form rather than specifying a table, or perhaps we can put something in there that says to the effect of any applicant is encouraged to reach out to the respective compliance office for assistance in this process, to at least let somebody who's coming to the rules and just reading them have it to call their attention that there is help available and that we encourage them to use it.
No, I agree. Thank you. Thank you. I mean, great feedback. I mean, Member Powers?
Yeah, I'm just a little confused where it says the filing of the petition will happen with the clerk of the board downtown at the county admin building. I thought we just talked about all these filings occurring at the Old Grove location.
Yes. You know, I mean, and that has to be replaced. I mean, to the Old Grove location. Yes. Okay. And electronically. Yes. That got addressed.
Okay. Thank you.
Yeah. Good point. No. Good. So thank you so very much. So continuing, you know, I mean, with Rule 14, I mean, are there any comments to Rule 14? So, okay, so yeah, that gives them, I mean, kind of good overview, I mean, to petitioner. Okay, perfect. Rule 14, I mean, the county also has, I mean, suggested edits, which may actually come, you know, to come into fruition. We just need to work on Rule 14 and how to put it together. So, I mean, Mia, could you please go to Rule 14? I mean, what county suggested edits are. Thank you. And it's at the bottom of the page. Look, we're on page 2. You know, there's hope. Okay, good. So again, they are making a suggestion of that there should be adding a requirement in subsection B, which already exists, to include those petition forms for the actions and can be viewed at variance. I think, that's really very good. I truly believe, that maybe we need to review Rule 14 with the edits that are submitted here and maybe make it just progress in a very, smooth fashion. Comments on Rule 14?
Okay, so if I'm at the right place, this section, the subsection B that they're suggesting to add the forms or maybe a reference to the forms, that's on page 7 of 22.
Yes, ma'am.
So 7 of 22. So subsection B is currently all petitions shall be typewritten, double space, blah, 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 right?
Yes.
So it's basically about the format.
Yes.
So, okay, adding a requirement to include, okay, so, so I guess if we're adding a requirement that they use the forms, that means that it would exclude if they submitted something just and didn't use the right form. So I would suggest that maybe we say we strongly urge, or it's highly recommended to use the petition form and other accompanying forms that are available at the APCD Hearing Board website. But I wouldn't necessarily want to exclude something. I guess I'm kind of thinking along the lines of, some people that are in jail, in prison, and they try to file a writ of habeas corpus, they might, they might just write it all out, and it might just be in writing, it might not be in the right format, but the court is still going to consider it, and not just kick it because it's not used in the right form. So I guess I'm thinking I would want Rule 14 subsection B to highly recommend use of the forms, but I wouldn't want to say it's a requirement, because I wouldn't want to just have somebody feel like they're excluded based on a formatting technicality. Does that make sense?
Absolutely. Yeah, I agree with you. Definitely. Thank you for, highlighting that one. So, that definitely with the suggestions, that's so, Ms. Helms, with that one, that will be good. Very important.
Yes, happy to incorporate.
Yeah, thank you for highlighting. Yeah, no, thank you for highlighting that one. Thank you. Perfect. Any other comments, on Rule 14? Thank you so very much. And I think we are at half point. This is good. Rule 15. Excuse me. This is petition for regular variance.
Yes, here I believe we were just trying to clean up the language and once again demonstrate what we are looking for in a petition for variance. But we could also include, I don't know if it would be appropriate to include links to forms here as well, if that's what the board's looking for.
Yep. The district's suggested edits are in related to, instead of repeating statutory requirements, it says, instead of repeating, consider referencing statutory requirements, in Rule 15. So that anything that has to do with this rule, Hearing Board Rule 15, is never misaligned, with statutory requirements. And then they also said for section D, consider identifying when a variance petition should include a schedule for increments of progress. For example, I mean, that may be required only for variances lasting for a year or longer. On subsection G, consider adding to the end of the sentence in the units of measure specified in the permit to operate of the applicable regulation. You know, so Ms. Helms, I mean, what, you know, I mean, do you consider, I mean, about referencing statutory requirements in this Rule 15? Will we be missing anything?
You know, so it's, I think it's a matter of the board's preference at this point. If you're looking for a document that gives petitioners what they need, the findings that they're going to be looking to make in one document, you can go ahead and outline the requirements here. If you're looking for brevity, we can say, you know, in accordance with the health and safety code. If we want a little bit, you know, of both approaches, we can say, if in the event of any, or maybe actually even at the beginning of our rules, just a general statement saying, in the event of any conflict between our rules and the health and safety code, the rule requirements of the health and safety code govern, which I think we actually included, if I recall correctly.
Yeah.
So yeah, I don't think there's any issues with being out of alignment with the health and safety code. It's a matter of preference at this point.
Correct. I know definitely that when these rules were revised last, you know, the access, I guess, not to internet, it's not the internet in as much as printing, you know, I mean, therefore was a little bit more challenging at the time. So right now, certainly almost everybody has a phone and they can actually access it. It's a little bit more prevalent, but that's when, you know, it was decided, you know, I mean, that to pretty much not repeat them here in these rules. So that will be one packet guidance, you know, for petitioners. So that was the intent, as I recall it. So that's just wanted to add that, I mean, as reference, I mean, to the hearing board members right now. I do like brevity personally, but that's not my personal choice. But I need to definitely ensure that, you know, our petitioners understand, you know, what is expected of them. So any questions or comments?
Yes, so I have a comment. I think we should leave the, I think we should leave the, you know, the repetitions here in the hearing board rules, only because these hearing board rules are not only helpful for the public, for petitioners and respondents, but also for us as hearing board members. And it just, I'm really glad that Ms. Helms, that you already identified that a conflict of interest provision, a conflict of laws or rules provision is what's needed to deal with any statutory, you know, changes over time, and we already have that. So hooray! So I think we'll just leave it as, yeah.
Okay.
But then these additional additions like subsection D and subsection G that the district is adding about, like adding at the end of the sentence in subsection G, in the units of measure specified in the permit. I think that's very helpful. So I think we should add that. For D, I know you love increments of progress. So what do you feel about that addition to subsection G, Chair Rodriguez? I would defer to you on that.
Well, you know, it's a requirement, definitely. I mean, that if it's a year or longer, I mean, that so as long as we can actually say, I mean, that like an example, but not the only requirement, that would be good. And I say that, I mean, the increments of progress are good to make people realize, I mean, that the enormity of the task ahead of them. I mean, that, and that's why, you know, scientists and engineers do it, you know, all the time, so that you can actually get the resources. And a project of 6 months requires as many resources, depending on the complexity, as one that is going to take, you know, 1 year. It just, you know, extends the time. So if we can actually add it as an example, as opposed to just the only requirement, I mean, that if it's 1 year, I will be just fine with it. For example.
So that would maybe be under
so compliance
in subsection D, a proposed schedule of increments of progress.
Yeah.
If necessary, including but not limited to the following. So where would we put this example? a proposed schedule of increments of progress.
This is to the following, the date by which contrast, the date, whether or not. So this actually says nobody is required, but not. You know, I mean, after the comma, compliance schedule, I mean, it could actually say if required for any, I mean, the regular variance, I mean, for 1 year or longer, but maybe required, I mean, just, you know, I mean, as a part of the conditions of variance conditions or something like that. Emily, what do you think about that?
You know, do you mind repeating that, Chair Rodriguez?
I mean, on that one, it says, no, I mean, a proposed schedule of increments of progress is required for variances, I mean, lasting 1 year or longer. However, I mean, they may become, I mean, a requirement as part of the conditions of the variance.
So I
Yeah.
guess we're trying to figure out with the district
to-
suggested addition and then with the red lines and, you know.
Oh,
updated
where to
text, where
add-
would we actually put it?
Oh, let's see.
Yeah. Do you have your red line on the?
I do. You know, if you don't mind, if I understand the board's intent is to incorporate the district's comments, if I can think on how to best do that and present it to the board, would that work at our next meeting?
Yeah.
Yes, ma'am.
Oh, great, thank you.
But how about, but G, however, is critical, I mean, on that one, so.
And G is
Yes,
easy,
please
you
adjust
know,
that.
it's just add it to the end of the sentence. So,
Mhm.
Yes, no problem, thank you.
Perfect. Any other comments on Rule 15? Good. Can we move to Rule 16 now? I guess so. Rule 16 is about, you know, petition for interim variance, you know, I mean, Emily.
Yes, this was added just because I don't believe our previous rules addressed interim variances.
Correct.
And we were hoping to provide some clarity on that point.
Are there any comments, I mean, on Rule 16? We do have a comment, you know, I mean, by the district, and it says, please update Rule 12 as it appears in the red line version with Rule 15. Take a look, Emily.
Oh, that makes sense.
Okay, thank you. Okay. Any comments on Rule 16? Okay. Then let's move on to Rule 17, which is petition for emergency variance. I mean, Emily?
Similarly, we were just looking to put all the requirements for an emergency variance in one place, so that would be easily found by petitioners.
Yes, that is correct. District is proposing the following on the Rule 17. I mean, it is just removing all the requirements. I mean, in referencing APCD rules 97 and 98 instead. I do, again, I mean, it's a whole packet, a whole guidance document. I would rather keep it here as well. Any other comments from the members of the board? Mia, are you there?
I am here.
Okay, good. I just don't see, you know, I mean, the squares and, you know, and member Schlick, you know, I mean, she's still on, Mia? I just don't see her square.
I'm still on, I'm just,
Good.
sometimes my video is messing up, so but I'm still here.
Okay, good. Thank you. You know, so any comments on Rule 17, petition for emergency variance? Good.
It looks fine as in the red version.
Yep. Good. I mean, with no comments, let's move then, you know, to Rule 18, which has to do with permit appeals. Emily.
Chair Rodriguez, we didn't propose any substantive edits to permit appeals.
That is correct. The district, however, does have a suggested edit, and it says that, to include the caveat to the bottom of section A, that reads as follows within quotation marks. It says, however, as provided in Health and Safety Code, section 42309, the hearing board is not authorized to change permit conditions. Ms. Tiagi, yes, ma'am. I think that will be a very good note, for clarification and alignment.
Thank you. Appreciate that.
Mm-hmm.
I'm fine with that addition.
Yes. Any other comments? Good. Any other comments to Rule 18?
It does say also the district is suggesting a reference to the APCD Rule 25 in subsection B.
Oh, I skipped that one. Thank you. Vice Chair Slick.
Where do we put that in?
B, a reference to APCD Rule 25, which applies to appeals.
Maybe just at the end say, see also APCD Rule 25.
Shall we allow Ms. Helms to?
Yeah, maybe she can.
Let's actually do that.
Place. Yeah, okay. Let's just defer to her and she'll figure it out later.
Yes.
Happy to.
Perfect. Any other comments on Rule 18? Good. Let's roll, to Rule 19. It has to do with amendments. Mia, could you please go back to Rule 19?
Yes, and these changes were proposed just because we thought they could use some clarification based on the board's existing practice, and the language was a bit awkward. So.
Yes. And the district suggested edit was, instead of for this to read application, could you please use the word petition for consistency? And I actually have to say, that Ms. Mahoney, Ms. Tiagi, that I always called it an application, and it's truly a petition. So serious. That's the name of the form. Oh God. We all can learn. So I think, it is, that suggests an edit. That it's easily to be followed. Any other comments? Nope. Okay.
The part about the part in the district's comments here about Rule 19 about consider adding a definition for submitted for decision.
Yep.
I don't really know that that's needed, but if it was, that would be added to the definitions section. Is that what the district is offering?
Yes, that would be what we were suggesting, but again, that's within the board's discretion. We just weren't sure if that was a phrase that people would understand automatically. And it's pretty important to the process of the hearing board because it's submitted and then you make your findings. So, but maybe it's explained somewhere else and I'm missing that, or maybe it's intuitive. I don't know.
Nothing is intuitive. Okay, that every single individual tells you something is intuitive. It's only for the designer. Just my view. I work with many IT people. It's intuitive. No, it isn't. Okay. No, that's a good point. I added it to the definition section on that one. Yeah, I think it's good. Yes,
I
ma'am.
think,
Yeah,
I think
Emily?
Ms. Helms has
Oh, yes, I would just ask the board to give the proposed definition for submitted for decision. I'm not really sure what that would be.
I don't really know either.
I don't know. I don't know either. I just put it on my list. Maybe that's why. I mean, even though I highlighted in my notes in red, which is I skipped it. So let's actually park that. I mean, for a little while. How about that? And we can always come back to that. Is that okay?
Yes,
Perfect.
of course.
Okay. In Rule 19, any other comments in Rule 19? Good. Okay, let's then move to Rule 20, which is entitled Answers. Emily?
This just adds some further detail as to filing and serving answers.
The district actually also had comments on this. I mean, the proposed rule or proposed edits, note that it says in subsection B, as in Bob or boy, requires answers to be filed and served at least 5 working days prior to the hearing. They should be reconciled or explicitly clarified with the Rule 21 requirements for submitted materials. So it seems as
So
though
my understanding of what submitted materials are is more like those are like the PowerPoints that people submit. But they're not like the legal documents themselves, right? They're just supplementary to or complementary to. So that's anyway, that's my understanding of it.
So if I may, the concern is, I believe that it's 5 days prior to a hearing for an answer and then 7 days for all other submitted materials. I can see the concern there.
Yeah, that's what it seems to be the issue.
Yes, I think it's up to the board there if they want to go with 5 or 7 or, but I agree that it should be reconciled.
Yeah.
And when talking about answers, this is more like when the district is the petitioner and is petitioning us to maybe shut down somebody, right? Like an abatement order, and then the answer is more like the respondent is kind of contesting that perhaps. So I think the idea of 5 working days is fine because they maybe need a little more time. They're in the responsive mode if they're answering. So that's why I see the difference. And then the thing about submitted material being 7 days prior, we usually allow it anyway for good cause, even the day of. So I don't really know that the 7 days is all that significant. Because it's usually it's just additional complementary material usually. I don't know. You know what I mean? But I think the 5 days, giving someone the chance to file their answer, maybe the petition was filed the 7 days prior or however many days prior, but then someone might want to answer it and respond. So giving them a couple more days I think that's a good thing. It's okay that it's different.
Oh, in that case, I think we can easily fix this by just saying in our submitted material section, unless otherwise specified in another rule, it'll be 7 days. So they'll still have the 5 days for the petition for the answer, but 7 days for all other types.
And the 7 days also comes, so that the board is also prepared. For the hearing. It just there are a couple, that have instances in which we actually have received absolutely nothing. At the time of the hearing, it get very convoluted, and the hearing board members could not be ready, So again, that's replying back and forth. As the Vice Chair Schlick, indicated, we tend to accept it, but I would like, to see, to be prepared for the hearing, so it needs to make the mail, or at least the email.
And it may be somewhat of a moot point because here we're talking about 5 working days and in the other sections, we're talking about 7 calendar days.
Wow, that's a good observation, Member Spencer. But Ms. Helms, what you're suggesting is that we put in Rule 21 submitted material in between the phrase emergency variances and has 7 days. We put, and unless otherwise specified by any other rule, something like that. That's where we would put that phrase.
Yeah.
Yes, that would be my thought.
Yeah. One question for the clerk of the board. Mia, are we ever going to get the mail package again? Please say no. Everything's going to be an electronic transmission.
Madam Chair, at this time, we plan on continuing with the electronic transmission. However, that once we transition into in-person meetings, the electronic transmission of any material submitted the day of the hearing may be required to be submitted in hard copy for distribution for the board.
Okay.
So that would be something the board may want to consider as well.
Yeah, so those 7 days, I mean, need to stay so 7 calendar days. Otherwise, we will not be making, your dates either. Okay. Yeah, I think, that the 5 days on response, I mean, or an answer rather, in the 7 calendar days on that one, that'll be, yeah. Would be, okay. I don't think, there's a need maybe to reconcile, except, for the wordings that you just suggested, Emily. Any other comments on Rule 21? APCD indicated has a suggestion, I think. It says, consider identifying which materials are not subject to this requirement, if any. For instance, the visual presentations mentioned in Rule 23. I mean, Ms. Mahoney, are we going to get now, the statement from the APCD as part of the submitted materials as we used to get? Usually get, a fairly good summary and position statement. Will that continue?
Yeah, I think regarding Rule 21, I think what we're trying to identify in our comment regarding that rule is that in Rule 23, I think it says that visual presentations such as slideshows are permitted. And so when it comes to submitted material, this rule has, deadlines for submitting those materials. So when I read through it, it just seemed like it might confuse, a potential petitioner or someone less familiar with the hearing board process. So that was kind of, I think, our thought behind our suggested edit here. I think when you read those two rules, it might be questionable because it says visual presentations are permitted. So it might make a reader think that you didn't have to submit, a slideshow 7 days in advance. So it sounds like, and in recent hearings, it has been the case that a slideshow or visual presentation does need to be provided 7 days in advance, or on the day of, for good cause, it can be admitted to the record. And so that's the current procedure, but, we drafted these comments a few months ago. And so I think it just could be clarified either in submitted material or in Rule 23, just to not give the impression that a slideshow can just be presented the day of.
Okay.
I think this is a marvelous observation. I think maybe this is also an opportunity for us to consider merging the two rules.
Yeah.
You know what I mean?
Yes.
Connect them up, because that's what we're talking about when we're talking about submitted material is is material that's going to be presented and used in presenting the matter to the hearing board. So maybe we can ask Ms. Holmes to add this to her list of things to rework, and then when we come back, we'll take a look at a merging of these two, perhaps.
Yes, that seems quite simple. So, well, I said that now, hopefully.
No, that's really very good, Tono, because definitely with the going online here, there have been, I mean, fairly good presentations and very succinct. I mean, but nonetheless, you know, I mean, presented on the time of the meeting. Right now, I know we have to go back, you know, to more traditional, I mean, submissions here. I like that. Thank you. Good job.
Chair Rodriguez, alternative member Engelmann is has his hands raised.
Oh, thank you so very much. I mean, go ahead. I mean, please.
Okay, thank you. I was just noticing that in a couple places we're referencing good cause, and we're wanting to provide this as a guide for petitioners, and we haven't defined good cause anywhere as far as I know. I'm wondering if we need to add a definition of good cause in the definition section, or a reference to.
That would be a very good cause to add it. It is true. No bad.
I would love to hear our counsel for the hearing board's input on that.
Yes, absolutely.
Oh yes, I've never I think the term good cause is intended to encompass the sort of the situations that you can't necessarily define. I think it would be very hard to come up with a definition for good cause. And it would definitely limit the board in their abilities to grant certain things. If you wanted to come up with like, you might say good cause may include but not be limited to the following.
Yeah.
If you wanted to come up with a list, I think the board would need to give us some really clear guidance on what they thought constituted good cause there. Otherwise, we would probably recommend keeping it general.
That'll be said, definitely something for a little bit of homework and discussion for the next one.
Yeah, I mean, because good cause is one of those things that like legal treatises are perhaps written on. So it's like, yeah, I think it would be hard to put a pin on it and define it specifically. It's you know, it's this idea that, you know, judges have to consider good cause when they're making their rulings and allowing parties to continue a matter or not. So there's it might just be kind of like we might be fish swimming out of water for us as a board to try to define that, but I don't know. So
yeah, you know, I mean, I hear you. I mean, it will actually have a different tint, you know, depending on financial aspect of the different, I mean, the rubrics, if which we actually look at this thing holistically. I have a roadrunner right across of my window. Yeah, you know, I mean, let's actually take that. I mean, maybe a little bit of homework on that one, not too much. You know, let me see, but no, for maybe additional, I mean, consideration here. Thank you, Steve. Absolutely. I mean, that good food for thought.
Thank you for considering it. Yep.
Oh, I know. I mean, that's what this is here for. I mean, so that's what we're doing this. Okay. Rule 22, notice of hearings. Emily?
Oh, this was just a little bit of cleanup to allow, you know, updates for the times, you know, on the, you know, allowing posting on the agency's website.
Yep. I mean, APCD is also, I mean, requesting, you know, to add, you know, their address here as well. You know, that it could be for posting. So.
Madam Chair, currently the district headquarters does not have a posting board. Therefore, we defer all postings to the CAC at this moment.
Okay. Any comments on that, Ms. Mahoney or Ms. Tiagi?
None for me, other than I need to look into that posting board issue.
Okay, so let's keep it as is. I mean, Rule 22, that is the proposal. Until we actually find something.
I guess my concern is that can't be the long-term plan, Mia, to keep it at the CAC. So I don't know how often we want to update these. Do you have
We
any?
can also just tape it to the front door of the building if that is also preferred. It is also, all notices and agendas are also posted on the hearing board's webpage.
Yeah, let me, if it's okay, can we come back to this one if we, I wasn't aware about the posting board issue, so I would like to try to look into that a little bit further if that's okay.
Absolutely. Yeah, no problem. So let's actually have Rule 22 remain as is. I mean, pending your investigation, Ms. Tiagi.
Okay, thank you.
Okay, no problem. Okay, I mean, Rule 23, hearing presentation. I'm sorry, Emily?
I believe the board's direction was for me to look into combining Rule 23 and Rule 21.
This is what happens, when I'm actually writing at the very same time. Okay, not multitask. Okay, I mean, how about Rule 24? Thank you so very much. I mean, that which is order of procedures.
Yes, so this language was actually borrowed from another district. It just very clearly outlined how the proceedings would follow. So it's just a suggestion and up to the board's discretion.
I definitely welcome that. I mean, to be honest with you, I mean, just to guide, everybody. Go ahead, Mr. Member Powers.
Yeah, I just wanted to step back on Rule 23, the hearing presentations, where it's currently written, these presentations are permitted but not required. And I just wanted to confirm that we did go through this a bit with the biodiesel processors in confirming that the district, I mean, I would change the language to recommended, but what I really would like to make sure is that the district is advising folks with petitions before the board that they are recommended to do this, so that they know that that's the way to go.
I think our only concern there would be that we don't want to be disadvantaging people who may not have the ability to create a PowerPoint. So that was the thought of saying that they were permitted but not required.
Yeah, I would say that if you've informed someone that they're recommended to do it, because my issue before was the district always does it. So if a petitioner shows up and they don't have a PowerPoint, then they're immediately disadvantaged and they look somewhat like deer in the headlights. And that as a board member, I would like to know that they at least got the recommendation or were told by someone in advance that they're recommended to do this. If they opt not to do it, they do it with foreknowledge, as opposed to not knowing and then telling us again that no one informed them that they should probably do a PowerPoint.
Mr. Member Powers, if I may, that has been our practice in the past, including with New Leaf and currently.
Well, I must beg to differ, because I've asked at least one petitioner, were you informed that you should do a PowerPoint? And they said no. So if the practice since that time has been we always do it, I'd actually rather see it codified in a way.
Oh, yes, and when I suggested that we merge the two, we're not going to get rid of the language from Rule 23, but just that it makes sense for this kind of notification about presenting and being able to include visual presentations like a PowerPoint slideshow. We're definitely going to keep that. It's just we think it would be better to go with the part about how soon you should provide it to the hearing board, unless you can have good cause to say why you did it the morning of, right? So we're wanting to merge them, but we're not going to lose that, because we did talk about this in September about wanting parties that aren't the district to know that this is possible. So for sure, yeah.
Yeah, and I'll let staff know that anytime a petitioner comes before the board, where I'm sitting on the board and they don't have a PowerPoint, I will ask them, were you informed that you were recommended to provide a PowerPoint? That will be the first question I ask them. Thank you.
Thank you, Member Powers. We're currently, on Rule 24. Very good discussion. So, that's something not to wordsmith, the previous one. But right now, is just the order, of the meeting per se in Rule 24. Any comments, on proposed Rule 24?
Madam Chair, if I may, just to
Yes,
address the previous comment by Member Powers, I certainly understand that PowerPoint presentations are good aids for the hearing board and for the parties. But I just, as counsel for the APCD, just want to make clear that it's not Mary's or the other staff's responsibility to prepare the case for the other side. They're two separate parties. So I think, they tend to advise people as fairly as they can, but I think it's still important to understand that it's technically still two separate parties. So
yeah, I'll reiterate, I'll ask the question. That'll be my first question. If no one has informed the other party, I will see the district as having put that party at a disadvantage out the gate. I've said this on a couple of occasions. Prior to you becoming counsel, let me go ahead and finish.
Sure.
That the district always does a PowerPoint. They always do a professional PowerPoint. This isn't that different than a layperson coming before the district to give a public comment and not knowing the procedure. Where this typically disadvantages a petitioner the most is small business person who doesn't have lawyers and doesn't have staff, who doesn't know the drill. And so it doesn't disadvantage the large power companies, the Navy. It disadvantages the small business entity, and it gives the impression that the less powerful petitioners are being selectively disadvantaged. That's my issue.
Member Powers, if I may, just briefly, I do understand your concern, and just for awareness purposes, during the proceedings, when you ask a petitioner or respondent that question, you might want to phrase it in such a manner as to say, was anyone at the company, addressed or was a PowerPoint recommended to anyone, because the exact person you may ask may not have been involved in every meeting or every conversation. So I just like to make that as a suggestion and a clarifying point.
And that is a fair observation, and I'll do that, because if the district is letting these petitioners know that they should consider doing that and they just opt not to do it, that's my only issue. I'm not saying they have to do a PowerPoint. It's just when the district comes in first, has a very professional PowerPoint, and they're basically on their heels trying to respond extemporaneously, it looks bad for the petitioner. And so I just want to know that they had a shot at doing that.
I would suggest that if that is a concern for the hearing board, then that information is better coming from the hearing board and not from staff, so who are, again, not the same party. So maybe there can be like tools or best practices or something else that's available on the website that would put that in. But I don't think that that APCD always has a PowerPoint presentation. And I think the intention of having one is really to assist the hearing board. It's not to create an advantage or a disadvantage for any party. And I think, like I said, it's just really not the responsibility of APCD staff to build the case for the other side. So
counsel, we're actually getting into a dispute. I've said my piece. You can tell me why it doesn't need to happen, but you're not going to convince me. And by the way, I raised this with the governing board.
Sure.
This is a problem.
I could tell my staff never to advise anyone to prepare a PowerPoint presentation. That's within the discretion of APCD staff. So that would be.
And you're being unfair. Your staff is preparing a professional presentation. a petitioner comes in who doesn't know the drill and looks bad. And they look bad because they didn't understand, in some cases, that they should have done that if they wanted to look like they had their act together. That's my issue.
And that's fair, but certain things are the responsibility of the hearing board and other things are the responsibility of APCD staff.
Well, and I understand. Just one final comment and I'll back off.
Finish, Bill. I mean, let's actually see, if we can actually.
This is the same response basically that came the last time. And so I reached out to the governing board and said, governing board, we have a problem. The APCD is coming forward. APCD have excellent staff, excellent PowerPoints. They know this drill inside out. There's no problem with big businesses, with staff. They match them step for step. But we get the little rock crusher and we get the little tube manufacturer. They don't have full-time staff to do this. And they seem to get caught in this Kafka-esque red tape. And they're on their heels. And I have a fundamental problem with the big corporations having no problem with our process. And yet we have these small businesses that oftentimes are very honest with us and say, hey, I'm sorry, I misplaced that paperwork. I didn't know. And they get hammered. And so I understand the board or the staff does not feel this is their responsibility. For that reason, I reached out to the governing board and say, we have a fairness issue here, in my opinion. And so Vera, I would suggest you check with the governing board and see if there's been some communication about this, because if there isn't, I'll go back to the governing board and say, hey, I think we need to address it. I don't know how the rest of the board feels, but I was on this board.
Here's how I feel. I just want to share. I think this has been so important that you brought this up to us, because really, I think, Mr. Powers, Member Powers, when you're asking a party this question, if they are coming without a PowerPoint, we have it within our discretion to just say, we're just going to not have any PowerPoints today, just to keep the field level. So I think that's important for us to think about, and I think that's a great question if you're asking that at the beginning. But let's maybe ask about it when we're deciding whether or not we're going to accept the submitted or helpful materials, right? And the visual presentations. That's something we should be considering, is the fairness.
And great position. I mean, and my comment was going to say, I mean, that let's go actually back to training. I mean, that it is a verbal presentation and the verbal, I mean, the material that is presented, the one that we need to actually take into account. I mean, certainly, the APCD has their position statement. I mean, the petitioner will actually have their position. The aids are really very nice. I mean, to keep everybody focused, but also, not a requirement. But I would actually say, that this is a very good conversation, Bill. And I think, that you actually bring something that is, a very important part of equity, regardless of the size of company that you may be. Okay. So, so let's actually see, maybe a little bit later, on the house, right now we actually have the what. I am not, canceling the house on this one because this is really very important. Okay. Let's actually take a look at rule number 23. Which is we need to rephrase it. Maybe there may be a need, there to actually refine it. How about that? I'll take that into consideration here, okay?
And if I could make a 10-second, 15-second final comment. If the rule recommends that a petitioner do a PowerPoint and the district informs them that they should do it, they will do it. I like the district's PowerPoints. I want them to keep doing them.
Yes.
If you tell a petitioner to do a PowerPoint or recommend it, they will do it. We won't have to make these decisions on a case-by-case basis. Thank you.
Thank you, Bill. And thank you actually for going on to the governing board as well on that one.
Thank you.
Where were we? No, absolutely. So we were definitely, back into, the rule 24. I believe that there are no comments. No, we can actually say that as is. Rule 25 is an official notice is entitled. Sorry, I just lost my.
I'm sorry, Chair Rodriguez. I had some comments about Rule 24.
Oh, go ahead, please.
Just because so this is all kind of brand new, because our previous Rule 24 had, where is it? Our previous Rule 24 had about 7 items. And the new Rule 24 has a lot more items. So I'm just wondering, and some of these I'm not familiar with us doing, like fee waiver determination, small business essential public service determination. So
Yes.
there's just a few additional things here. So maybe, Ms. Helms, can you just speak to that?
Oh, yes. So we had, as I mentioned, we had borrowed this language from another district. If you're asking particularly about the fee waiver, we actually do, the board does permit fee waivers. So we thought that was a good time to address it. And then I think everything else is pretty standard in that the board already does this. They allow opening statements and closing statements and rebuttal. It also offered some clarity as to how much argument we would allow. I know that sometimes the petitioners or the respondents are unclear about when the hearing is open and closed. But like I said, it was completely optional at the board's discretion.
So one thing I'm noticing, I think our typical procedure is a little bit, it's a little bit more like how it was the crossouts. So usually we just have appearances, summary, the moving party, the responding party, whereas the updated version has an opening statement by one, then the other, then it goes to evidence by one, and then the other. So there's just, I just want us to be aware that if we're wanting to do the new suggested version, there's more back and forth instead of just kind of just go district, go responding party. You know what I mean? Like there's a little bit more back and forth. So we just need to be mindful. Do we really want to be doing that, or do we want to keep it more simplified like we had it before?
I would definitely, again, we just wanted kind of to align to what, that some of other districts actually were doing, and that was fairly consistent. But certainly, that if the board members don't want to retain the prior, I would certainly want to keep, the fee waiver, the requirement, because definitely that is important. And the small business / essential public service, as part of those elements. I think, that those are critical, and it has come, to the board on many occasions on my share. I think that's very important. Member Spencer.
Yeah, I guess this is more of a question for council. I understand that this proposal has a lot more back and forth, but in practice, do other hearing boards have a lot more back and forth than we do? I'm just curious what in practice our procedure is compared to other hearing boards.
Unfortunately, I can't really speak to that because I haven't been involved in actual other hearings, but I have reviewed the statement of proceedings, and that looks pretty standard as far as that goes. But how it actually plays out in a real hearing, I'm afraid I can't speak to.
Because I think it's fine to allow for more back and forth, but I'm not sure we should be necessarily required to have more back and forth.
Right. And I believe we built some flexibility in here. I believe unless, the chair in his or her discretion may alter the order of proceedings. So, and if we think this is too much back and forth, the board is free to reject the comment.
Correct. What is the preference? Measures like comments.
I would prefer the old version with the addition of the fee waiver and the small business determinations, just because these terms in the new version, like rebuttal and rebuttal, I don't know, it's just not as like, it's not lay people language, it's just, I think it just
legally,
it increases the complexity, and I don't know, I want people to be a little more relaxed when they're reading this and getting ready for a hearing board.
Yep, no problem on that one. Dr. Spencer. In the old version, or the existing, actually, the effective version of the rules, this, we're talking about Rule 18. And that actually, the order of procedures, however, includes the following, and I'm going to read, the effective version right now. A, announcement of pending matters. B, enter appearances. C, summary of evidence by district representatives. D, evidence and argument by moving party. E, evidence and argument by responding party. F, public testimony. G, rebuttal evidence or argument where necessary. With the same caveat, the chair may adopt reasonable regulations, but not limited to limiting the amount of time, for testimony on particular issues for individual speakers. So, again, we just wanted to kind of, to make more, I guess, the other, districts, but what the effective one I'm okay with, except, for those two elements, that I have actually indicated. The fee waiver, which is really very critical, particularly for small, entities. And definitely the recognition, by usually, the petitioner, that whether or not that they are a small business or essential public service.
And given that we have this flexibility to adapt the proceedings as we see fit, then I think it's fine to just take what we had before with those additions.
Okay. So Emily, did you make a note of that?
Yes, I have. I will be keeping the rule as is, but adding the suggestions regarding the fee waiver and the small business determination.
Yes, thank you so very much. Okay, excellent. Good. Where were we now? On official notice, I think, on that one, Rule 25, official notice, has no changes. It does have a numbering as it appears. If you guys can go, Mia, to the red-lined item. We only have, about, 25 more minutes, thereabouts. One, because, it's the top of this hour, and second, because I think, it is time, to take a bio break. Okay, Rule 25, official notice. There are no changes. There's only renumbering. Are there any comments there? Rule 26, that is evidence. Emily?
These changes were made basically to clarify. We thought the wording was a bit confusing.
Are there any comments from the board members on Rule 26? Okay, let's then proceed to Rule 27, which is just a renumbering. Next page, Nomia, thank you. Which is request for discovery statement and writings.
Yes, we made a few just language changes to this one. We thought the language was a bit superfluous, so.
Thank you. Comments? Rule 28, subpoenas.
See, the intent here was to just bring the requirements in line with the applicable law. So our intent is just to reflect the statute.
Any comments in Rule 28?
Just a quick question. Have subpoenas ever been issued in any of the proceedings?
If that's so not to my knowledge. I've been with the hearing board for about 8 years and I've never seen one.
Thank you.
Pretty standard section, however, for all the rules, though. Rule 29, continuances.
Once again, we were just trying to clean up the language and make it read a little nicer and make it more clear about when the board was willing to entertain continuances.
The district, however, has a suggested edit in 29, which is, it says update rule reference in subsection A within parentheses. Let's see. It says Rule 23. Oh, got it. Yes, at the very end. It has to say different number, which is what, 29, isn't it? Nope. Yes, Rule 29 is at the very end of A. Did you catch it, Emily?
Oh, I apologize. What was that?
Did you catch, that the district, suggested edit to Rule 29, continuances,
Rule 29.
which is at the very end of A.
I see it. It says,
Oh,
with
Yes.
a good faith effort to comply with the requirements of this Rule 23. So just changing it to 29
oh yes, of
As-
course.
of the
Perfect.
updated rule number. Good catch. Thank you.
Yes. Any comment on Rule 29? Good. Rule 30. No, Aminta. Going
Rule
back to the
30,
red line
we
item.
didn't- oh, I'm sorry. We didn't propose any substantive edits.
The district indicates, however, that consider allowing for email withdrawals. Rule 30 on that one, on the red line, version 1, 2, 3, 4, I think the fourth line, last sentence, I said, if email shall not be accepted, the district indicates to please allow, the acceptance of email withdrawals. If that's how I understand it.
I feel like we talked about this in September, that if they're gonna do it by email, they also need to like talk on the phone. Like the idea here is we don't want it getting lost in the email and then nobody knows that something's been withdrawn, right? So to conform to the like more direct requirements that maybe I don't know.
Mary, could you please weigh on that? How would that actually work out? Does the APCD require both email and a phone call? Uh-oh, Ms. Mahoney?
I can weigh in,
Yes.
in case Ms. Mahoney is unavailable at the moment, but it does say that, for instance, with fax, you can do it with fax with a follow-up hard copy, and it does seem like email is used more commonly now than fax machines. So I think, we're open to whatever follow-up mechanism is better suited for this day and age, but it does seem that maybe, email is just as valid as fax, if not more so.
So, but you actually required a fax and a follow-up and an email and a follow-up.
I think the
that's a great
follow-up is
question.
appropriate, and I don't really personally have a preference whether the follow-up is hard copy or phone. I think for me, it would be whatever the clerk is thinks is the easiest for her.
Okay.
Madam Chair, if I may clarify that currently petitions filings are being accepted via email. And there is email communication to confirm receipt for consideration of the hearing board.
Okay. Well, with that, I believe that I know that there should not be a problem whatsoever. That definitely accepting email as a means of withdrawal. Any comments from the members of the board? Okay, thank you so very much. And thank you for the feedback on that one. Rule 31, failure to appear for a hearing. There are no
Chair Rodriguez, may I request a brief break?
A brief break?
A brief recess.
Sure.
Thank you.
Shall we just take a 5-minute break, just to stretch our legs?
Thank you.
Okay, sounds good. So 5 minutes, we'll be back at 11:37.
Thank you, Ms. Holmes. That was very helpful.
Thank you. I apologize for the interruption.
It's an interruption. It's something that you needed, so that's really very
I
good.
think we all needed a little refresh, so that was good.
Okay, perfect. So thank you again. I believe, that we were in the rule 32. Findings. Are there any comments, on findings? To written findings.
Now, the intent behind these revisions, we'd had some requests for findings before from petitioners, and we went and we looked at the statutory requirements, and we were just trying to bring that in line. So that's where these proposed changes are coming from.
Perfect. We do have a suggested edit, from the district, which is very minor. It says Rule 22 findings clarify that subsection B applies to written findings. It says written findings, but they also wanted that subsection B to also say written findings.
I have no objection to adding written in between when and findings in subsection B.
Any other comments? Perfect, thank you. You can actually tell, that what I'm actually, the goal here is like to finish as much as possible, if not all. Okay. Rule 33, compliance schedules. Emily?
Oh, just trying to clean up the language and clarify.
Correct. The district actually says, consider also referencing Health and Safety Code section 42357, which permits modifications to the increments of progress or a final compliance date with a showing of good cause. I think that is important as well.
That will be added.
Yeah, I think, that's definitely very much needed. So good job on that one. Any comments, on that one, by Chair Schlick or any members of the board?
It seems like it would be fine to add the suggested addition regarding Health and Safety Code 42357.
Absolutely. Thank you so very much. Compliance schedules. No, Rule 34 decision. Only one decision, sorry. Rule 34 decision.
Once again, just trying to clean up some awkward language.
The APCD suggested, that to add a phrase here that indicates that the decision will be made available to the public on the APCD hearing board webpage. APCD wants us not to actually become, more technologically, available to people. Just a joke, that one. Yeah, I think, that the suggested, the edit, that definitely brings value to Rule 34. Any comments? Perfect, thank you.
It seems fine to add that we'll post it on the webpage. That seems fine.
And Rule 35, effective date of decision, Emily.
So we were reviewing this language and we didn't really feel like it added much value. So we went ahead and we suggested removing it and just leaving it as when the decision became effective.
District, however, indicated that, we should consider including the exception that applies to emergency variances, which become effective up to 2 business days prior to the hearing date by using the date when the APCD at the district was notified. I think that that is certainly, I mean, of great value. I mean, so I would definitely suggest that we adopt, I mean, the districts, I mean, the suggested edit. Any comments from the board?
Yeah, I would be okay with adding the emergency variance exception and, but otherwise striking most of Rule 35 and just keeping it simple, as suggested. So that looks good to me.
Perfect. Okay. Team, board members, the last one. Rule 36, rehearing.
So we did move some of the language from the prior rule concerning rehearings down to 36 rehearing. Yes, and basically I think it outlines, the intent is to outline the health and safety code procedures for a rehearing. We also had wanted to bring to the board's attention that there is a slight ambiguity in the current practice as to whether when a rehearing is requested, if the request needs to be put before the board, like the consideration, like, consider whether or not we will rehear this matter and then schedule a separate hearing for the rehearing, or whether or not the board can just put on the agenda that we will consider this, and if we approve it, then we'll have the hearing. So our intent there was to address that issue.
Mm-hmm. The district, I mean, also, I mean, that made a couple of suggestions. District indicates to subsection C to add or other interested party after testimony of the petitioner. Again, another party other than the petitioner may be interested in being heard at the rehearing. And the second suggestion, would be to item D as in David, says add reference to Health and Safety Code section 40821, or specifically include with not fewer than 4 members present to incorporate additional statutory requirement for initiating a hearing. I think, definitely, particularly D, that's a good suggestion, and also it mirrored something a previous one. I would definitely vote on that one to add APCD edit. And let me go back here, out of here. Let me go back. I mean, Emily, did you see, I mean, the petition here from the district, in C, item C, after petitioner?
Yes, I have no concerns. It's at the sole discretion of the board. So if the board wants to hear testimony from another party, they may. So no legal concerns.
Yeah, perfect. Measure Schlick?
Yeah, it looks fine. So it looks like it's on the 4th line at the end of that sentence.
Yep.
In the hearing board sole discretion, testimony of the petitioner or other interested party. That seems fine.
Yeah, that is correct.
Mm-hmm.
So, I mean, adding, the suggested edits from APCD.
And just a quick question, is this also our historic procedure? I remember the Navy, we reheard the Navy. Did we vote to let them go forward with the rehearing the same day they presented their rehearing?
Now, Member Press, I believe this was intended to address that situation. We weren't entirely sure how to. I believe we voted and then we reset. But we wanted to make sure that we had clarity moving forward.
So in this case, a party wants to be reheard. They're basically hoping that we will grant that rehearing, and they need to be ready to go. They immediately will be heard.
Yes, but that is entirely at the discretion of the board. If they want to create a procedure whereby we vote and then we set a new hearing, that is fine as well.
Understood. Thank you.
Yeah, because under subsection C, it says, place it on the agenda for the next regular meeting. So it seems like, you know, someone might ask for a rehearing. They might not ask for it at the same day of the original hearing, but as soon as they request the rehearing, then they're just going to be put on the next agenda. So
Okay.
it's not looking to me like we would do it right on the same day.
Yeah, does it mean noticing requirement? I mean, the Mia on that one. Is that part of the issue as well?
Yes, Madam Chair, if a rehearing is needed, it would need to be properly noticed versus the separation for the petition to consider rehearing. That would also require separate notice.
Correct. Perfect. Okay, so I do not know yours, I mean, but mine is not only bleeding red, but blue and green all over for all of the, suggested edits. I think that this has been a fantastic time spent together, albeit not rather long. Are there any other comments from the member of the board or APCD?
Sorry, member Powers. I think now I get what you were saying. It's just been a long meeting. Yeah, so the petition is initially for whether we're going to rehear it or not. And when we decide whether we have to notice that meeting that we're going to decide whether we're going to rehear it. And then if we decide at that meeting that's been noticed that we're going to rehear it, then we go ahead and hear it right then. That's
correct.
That's interesting.
Yeah.
Because that would mean not only the petition's going to say, like, here's why we need to rehear it, but here's everything I want you to consider if you do decide to rehear it. That's interesting. Maybe I just want to think about that. But anyway, I get what you're saying now. Thank you, Mr. Powers.
Yeah, that rehearing takes its time, that's for sure, about 2 months thereabouts. That's so because of the noticing requirement.
Chair, may I ask, so is the board wanting to consider further how to handle rehearings, or are we suggesting new language?
So I've never been through this situation before because I've only been on the hearing board for a couple of years now. Member Powers and Chair Rodriguez have been through this, it sounds like, through the Navy case that you guys are mentioning. So when that happened, the request for rehearing, is that what happened? Is just as soon as it was granted, or was it granted or was it not granted? It wasn't granted. So, but with it being requested for rehearing, was all the materials given to the board?
Yeah, I see.
So you kind of knew what was going to be talked about if you did grant the request, or?
Yeah, I see Ms. Mahoney shaking her head, but I recall we did rehear the Navy, and we actually were annoyed with the Navy because they kept repeating the same arguments that they'd done initially. We said, hey, you are being reheard to provide us with some new evidence, something that would make a difference. And they didn't do that, but we did rehear them.
I recall, definitely a similar sentiment, but what I took away from it was they requested to be reheard, and that was sort of rejected in the first place. So I don't know if they had more to present. I suspect that they did, but that's the feeling that I got from that experience.
Yeah, it was a strange experience, and the Navy was insistent on continuing. They wanted to be heard again, and finally we just said no. But
right.
it did create some tumult, just trying to how do we cut this process off? So I don't have any language for today. It just, when it comes up, it can be complex.
It is, because I remember also the Marine base, also for some coatings, after everything was done, and that was like multi-year one. They wanted to kind of re-up. It's like, yeah. And the problem with them is that they thought that the rehearing had to be happening on the day that they submitted. I go, no, it has to be noticed. So it's complicated. Rehearings are complicated per se. So I think, that the sequential aspect that we're taking is much more effective, than just, but, it needs strategy with counsel as well. Go ahead,
The language as stated says that we will have the ability to hear the evidence on the same day as the consideration. If the board is looking for like a two-step process, we're happy to implement that via the rules as well. So we'll just need the board to say, give us direction as to whether they're wanting a one hearing or a two hearing process.
Well, it does say after shall be conducted at the same meeting unless otherwise specified. So, I mean, we do have it looks like we do have the discretion to set another hearing, but, and then I'm wondering, regardless of rehearing the matter, anyone can appeal what we decide, right? To what the next board above us, right? The California board, or take it to court, or
they can take it to Airbnb.
is that something that we need to have in our rules, or they just go figure that out with their own legal counsel?
Well, yes, these are our rules of procedure for how we conduct our hearings. So that would likely go beyond the scope of these rules.
Beyond the scope. Okay.
It's only the final decision, on that one.
My recommendation would be it be two-step, because we'll be under a lot of pressure to grant the rehearing if we have a petitioner before us with a phalanx of lawyers and stacks of documents saying, we put in all this time and effort and we want to be reheard now. So I think from a board standpoint, having a two-step process where they present the merits of their petition for rehearing and we adjudicate that. And if we go forward, then in 2 weeks' time or whatever it is, they lay out their arguments. That would actually, we wouldn't be so much under pressure to side with the petitioner, just based on them having spent time and money to be ready to go that day.
Yeah, maybe I'm not reading this comment, but it has to be a two-step process. The request for hearing is one, and then the rehearing per se, is the second. Maybe I'm not reading this correctly.
Yeah, as long as the two-step is there, it's fine.
Well, it's definitely two steps, Chair Rodriguez, but as it currently states, the default is that if we request if we grant the request, then we're going to rehear it right after we grant the request. That's what it says. The rehearing shall be conducted at the same meeting. So it is two different decisions. But this, I think Member Powers is suggesting some separation, some default separation in time and space between the granting of the rehearing and the actual rehearing.
That is correct. Okay, Mia, one more time, let's actually, do that. So the request for a hearing needs to be noticed, isn't it, Mia?
That is correct, Madam Chair.
And if the request for a rehearing is granted, that rehearing has to be noticed as well.
That is my understanding, Madam Chair. I will defer to counsel for that, for confirmation.
We don't see any reason why you couldn't notice a request for rehearing as well as a rehearing together, as long as it's properly noticed. But then again, it's not required. We could also do the request for rehearing at one hearing and then separately notice the actual rehearing.
Okay. Because definitely if petitioner notices both, requests for both, then they can be done the same day. But we should actually do that. I agree with Bill Powers. Thank you, Bill. So on those details. Yes, rehearings are complicated. And people are not happy either. So I do certainly see that the timing separation between the two to prepare all the parties involved. So yeah, I think that. So Emily, can you take care of that language then?
Yes, happy to.
Unless anybody else opines differently, of course. Thank you. Four minutes until noon. Okay, so I don't know you, but that's why I need to stretch my legs. So is there a motion by any member of the board to accept the discussed revision into a new working draft for further consideration for adoption at a later date?
I'll make that motion.
Do I get a second? Mia, please call the roll.
I'll second.
Thank you, Madam Chair. Member Gonzalez,
Aye.
Member Powers,
Aye.
Member Spencer,
Aye.
Vice Chair Schlick,
Aye.
Chair Rodriguez.
Aye.
Madam Chair, that motion passes with all members present voting aye. I just would like to clarify that at this time, a later date has not been identified.
No, thank you so very much. I mean, that Ms. Helms, I mean, that how long would it take you? What would be reasonable for you to present a new draft, to the board?
I think we can get this done at the next regularly noticed hearing. Mia, when would that be?
That would be the March 9th hearing.
Yes, I think that's feasible. But I don't know if the board also wanted to consider another special meeting, if this was going to be another
No.
in-depth review.
So that's actually, I mean, my suggestion would be not to put it, I mean, as part of the regularly noticed meeting. If we need to call a special meeting, we'll do it by then. I mean, that's unless I actually, have, I mean, anybody else who has some other consideration, I mean, or motion.
Oh, I'm sure. Actually,
We're really close. We're getting really close. So yeah, I think we could just fold this into a regular meeting.
Yep, I think so.
If I didn't account for the time that we need in order to get this on the agenda, that's an extra time. Maybe perhaps push it back to the meeting after the next meeting.
I think that will be much better. Thank you so much.
March 23rd.
Yeah, that sounds great.
Okay.
Madam Chair, that would be March 23rd.
Perfect. I mean, Madam Clerk, so let's actually do it there. I think, it would give us now much more time, to do that, so perfect. So I have, definitely a motion, certainly. I mean, that, no, that actually passed, I mean, with the revisions. So then if that is the case, then I would like to direct the clerk to notice this item for discussion and review, I mean, of today's revisions. I mean, for the meeting, regularly scheduled meeting on March 23rd, 2023. Do I get a motion to actually have these items for discussion for the March 23rd, 2023?
I would so move.
Perfect. I mean, Dr. Spencer, I mean, Madam Clerk, could you please call the roll?
Thank you, Madam Chair. Member Gonzalez?
Aye.
Member Powers?
Aye.
Member Spencer?
Aye.
Vice Chair Schlick?
Aye.
Chair Rodriguez.
Aye.
Madam Chair, that motion passes to schedule the discussion and review of today's revisions of the working draft for further discussion of the remaining portions for March 23rd, 2023. And for the record, that will be an in-person meeting.
Well, thank you very much. I mean, thank you, everybody. I mean, this has been a fantastic, I mean, dedication of your time and effort. I mean, the same thing goes now for the APCD and all the feedback that they have provided. This concludes our meeting. Our next regularly scheduled meeting is going to be February 23rd, 2023 at 9 a.m. Have a great week. We did it. Thank you, everybody.
Thank you.
Bye.
Bye-bye.
Bye.